This is 180 seconds of what you need to know from the world of litigation and investigations. Let's waste none of your precious time. This is Disputes 180. Today we're looking at data protection as it relates to investigations. These issues arise in both internal and government investigations, and they cover a mix of employment, criminal and privacy law. There's a careful balance to strike between the need to process data for an investigation and the protection afforded to individuals whose data is used as part of that investigation. Organisations must navigate a complex landscape of domestic and international legislation while at the same time having to ensure cooperation and transparency with government agencies. And for cross-border investigations, multiple regimes may apply at the same time, meaning that competing needs must be navigated from the different jurisdictions concerned. In the UK, personal data processing is governed primarily by two sets of rules. First, the UK General Data Protection Regulation, which effectively incorporates the EU GDPR following Brexit. And second, the Data Protection Act of 2018. The regimes apply to corporations established in the UK, as well as those companies operating outside the UK who use personal data is linked to activities at home. The rules also apply to corporations established outside the UK, even if they have no presence here, if they are processing the personal data of people inside the UK. There are 5 core obligations to keep in mind. First, there must be a lawful basis for processing personal data. Second, where special category or criminal offence data is involved, an additional and specific legal condition must be satisfied. Third, organisations must identify a lawful basis for any international data transfers, which is in addition to establishing a legal basis for the processing. Fourth, the data use must be proportionate. And fifth, there must be transparency, unless a recognised exemption applies. And 2 principles deserve particular emphasis. The first is data minimisation. Investigations should be tightly scoped with clear limits on custodians, date ranges and search terms. The second is transparency. Individuals should generally be informed about how their data is used, unless doing so would seriously prejudice the investigation. When responding to requests from regulators or prosecutors, data protection obligations do not disappear. Disclosures must still have a lawful basis, be reasonable and proportionate, and have no alternative, less intrusive means to provide the requested material. All the issues here are looked at in much greater detail in our chapter on data protection in the GIR Practitioner's Guide to Global Investigations, which is linked in the pages below. And that's your 180 for today. It was brought to you by the wonderful team here at Paul Hastings in London. If you want to join a live version, we host regular events at the Paul Hastings office, including our 2 flagship series, Developments in Disputes and The Future of International Arbitration. To make sure you don't miss out on any of this great content, follow our Paul Hastings LinkedIn page. And if you've enjoyed this edition of Disputes 180, why not look out for the next one? That way you'll have done a full 360.